feel the need that there is something they want to add to the record, just try to signal that, and we'll do our best to give everyone a chance to participate and add anything they think would be helpful. Why don't we start with Ms. Hill whenever she is ready, and Mr. Fitzpatrick is working on the screen here. I think we're good to go. All right, Ms. Hill, you have the floor.
Okay, thank you, Your Honor. For over 2 months, SB 23, which is a near total ban on abortion, has been imposing upon Ohioans the devastating and irreparable harm of being denied access to abortion in Ohio and being forced to continue pregnancies against their will in violation of Article 1, Sections 1, 2, 16, and 21 of the Ohio Constitution. Now, we've submitted affidavits detailing numerous of these harms. I just want to give a few examples right now for the court. One example, there was a young woman who was turned away from a clinic in Ohio because of SB 23, who had been so ill, throwing up because of her pregnancy, that she couldn't sit in a classroom to finish her high school degree. When she had to be turned away from the clinic, she ended up in the hospital because she was suicidal. We have more than one affidavit that talks about cancer patients whose physicians could not or would not continue their treatment because they were pregnant. And those patients then had to travel out of state, further delaying both their abortion care and their cancer treatment. And of course, the story of the 10-year-old rape victim who had to travel to Indiana to access abortion care has made national news, but our affidavits too detail at least 2 cases of minors who were victims of sexual assault and denied abortions in Ohio because of SB 23, just during the 2 months that it's been in effect. This continuous, severe, and mounting harm to patients, together with the risk of the imminent closure of one of the plaintiff clinics on September 15th, and our clear likelihood of success on the merits of our constitutional claims, entitles plaintiffs to a temporary restraining order against the enforcement of SB 23. So as set forth in our opening brief, Your Honor, plaintiffs clearly satisfy all of the requirements for a temporary restraining order. But today, I would like to focus primarily on 2 of the 4 elements: plaintiff's strong likelihood of success on the merits, and the indisputable irreparable harm that SB 23 is inflicting on plaintiff's patients every day that it remains in effect. First, as to the merits, the text of the Ohio Constitution, together with a substantial body of Ohio case law, make it overwhelmingly clear that Article 1, Sections 1, 2, 16, and 21 protect the right to abortion. We have to first start with the principle that the Ohio Constitution is a document of independent force, and that it can and must be construed independently of the federal Constitution by the Ohio courts. And in fact, the Ohio Supreme Court has found on a number of occasions that the Ohio Constitution provides more expansive protections than the federal Constitution, particularly when individual rights are at stake. And the Ohio Supreme Court has held the line on constitutional protections, even when the US Supreme Court has taken them away. So in the case of Humphrey v. Lane, for example, which we cite in our briefs, the US Supreme Court had reduced the protection for free exercise of religion under the First Amendment of the US Constitution in the case of Employment Division v. Smith. But the Ohio Supreme Court decided to hold the line and continue to apply a more protective standard of strict scrutiny to free exercise violations under the Ohio Constitution. Notably, the language of our Constitution is also different in some respects from the US Constitution, including the fact that the Ohio Constitution has an inalienable rights clause in Article 1, Section 1, the fact that the due course of law clause and equal protection and benefits clause have broader wording than their federal analogs. And of course, Ohio has the Healthcare Freedom Amendment in Article 1, Section 21, which has no federal analog. Here, the right to abortion is encompassed in the Ohio Constitution's broad substantive due process protections. So as the Ohio Supreme Court found in this case of Steele v. Hamilton County, Article 1, Section 16, which is the due course of law clause, together with Section 1, the inalienable rights clause, protects a substantive due process right to personal security, bodily integrity, and autonomy. And the court also found that intrusions on this right are subject to strict scrutiny. A common pleas court in this county has similarly found that these protections under Article 1, Section 116, and then also the Healthcare Freedom Amendment extend to matters involving privacy, procreation, bodily autonomy, and freedom of choice in healthcare decision-making, and that this includes the right to abortion, and therefore that restrictions on abortion must be subject to strict scrutiny. Those are the two cases, both called Planned Parenthood Southwest Ohio v. Ohio Department of Health, cited in our briefs. And I think it's important here to point out that it is a very well-established principle of Ohio constitutional law that the provisions of the Ohio Constitution should be read in pari materia. They should be read together holistically to harmonize. So these are mutually reinforcing provisions. Article 1, 16, and 21 that read holistically clearly protect a right of Ohioans to access abortion, notwithstanding the defendant's attempts to sort of individually each of those rights and explain why each of them in isolation does not protect those rights. In addition, Ohio's equal protection and benefit clause is violated by SB 23. Recent cases from the Ohio Supreme Court have stated that Ohio's equal protection clause may be more protective than its federal analog. Those are State v. Mole and State v. Noling. Of course, sex is a suspect classification under Ohio law, and SB 23 discriminates on the basis of sex. The text of SB 3 contains numerous references to pregnant women, and it singles out women for differential treatment based on pregnancy, which is a condition, of course, unique to women. Both as written and in practice, SB 23 clearly targets women, and it's also grounded in outdated stereotypes about women's roles as childbearers and mothers. SB 23 clearly flies in the face of this constitutional right by banning abortion starting at 6 weeks LMP, which is only 4 weeks after conception, 2 weeks after a missed period, before many women even know that they're pregnant, and well before the vast majority of women are able to access abortion in the state of Ohio. Thus, because SB 23 violates both Ohioans' right to abortion and their right to equal protection and benefit of the laws, it is subject to strict scrutiny. That means that the state bears the heavy burden of proving that SB 23 is narrowly tailored to a compelling government interest, which it clearly cannot do and has not done. Thus, as further argued in our briefs, plaintiffs have clearly demonstrated a likelihood of success on the merits of both of these claims. Now, just a few more brief words on irreparable harm, Your Honor. The record makes it abundantly clear that SB 23 is inflicting and will continue to inflict serious and irreparable harm on Ohioans absent injunctive relief. First, again, for the reasons I've just explained, SB 23 violates Ohioans' constitutional rights, and numerous cases indicate or hold that the violation of constitutional rights is always irreparable harm. But also, plaintiffs have submitted several affidavits documenting in detail the significant harms experienced by their patients as SB 23 took effect in June, some of which I just mentioned at the outset. Every day that SB 23 remains in effect, more and more pregnant women are forced either to attempt to travel hundreds of miles out of state to access care, or to continue pregnancies against their will, or to attempt to self-induce abortion outside the medical system, all at risk to their physical, mental, and emotional well-being. Moreover, Your Honor, with Kentucky losing abortion access on August 1st, and Indiana poised to ban abortion effective just 1 week from today, many patients are going to find themselves having to travel even further than they already do, which increases the expense and delays in accessing healthcare, which in turn both increases health risks and makes it more likely that those patients will ultimately be unable to access that care. So for all of these reasons, Your Honor, plaintiffs and their patients urgently need and request relief from this court against this unconstitutional near total abortion ban. And with that, I'm happy to answer any questions Your Honor might have.
Well, I guess one question that the court has, having looked over all of this material for the plaintiffs, and Ms. Hill, if you want to, or if you need to pass to someone else on any question, feel free. I want to make sure we have as good a discussion as we possibly can. One question that came up in the court's mind was, if the court grants the the temporary restraining order, what would be the state of the law in Ohio with respect to abortion rights or any restrictions? I mean, in the past, where TROs have been granted by Judge Hathaway in this court, Roe was still in effect. We don't have that anymore. So I guess the question for the court is, to entertain this relief, what exactly would it mean? Because I think the defendants have argued or at least the state AG's office has argued, and I understand some of the defendants are taking a different position. They've argued that this would, if I granted the relief you're requesting, it would mean that, abortion is lawful at any time. I don't think that's what you're asking for, but I'd like to make sure I'm really clear on exactly what it would mean to grant this motion. Could you elaborate?
Yes, Your Honor, I'd be happy to. So you are correct. We are not asking the court to rule that. What we are asking the court to rule is that the SB 23, which bans abortion as early as 6 weeks of pregnancy, is unconstitutional. And so if the enforcement of SB 23 were to be enjoined by this court, that would mean we would return to the status quo that's been in place for roughly decades in Ohio. Essentially, the pre-existing regulatory framework would still be in effect in Ohio. So Ohio had abortion access available until approximately 22 weeks LMP under prior law before SB 23. So we are only asking for a ruling that SB 23 is unconstitutional, and any other laws that were passed that regulate abortion or that are not currently enjoined in other proceedings would be in effect.
Okay, so there were a number of other preliminary injunctions that were in effect that have been dissolved since the Dobbs decision. But I guess I just don't want to create a chaotic situation by entertaining this relief or granting this relief. Are there preliminary injunctions in Ohio in effect on other restrictions that have not been dissolved? I guess that I just don't, I think,
right,
concerned about creating an inconsistent situation or something where people don't know what the restrictions are.
I see. Yes, Your Honor. So the two injunctions that were dissolved on the day Dobbs was decided were in federal court cases, and that was SB 23, so the current ban, and then the other one was the so-called D&E ban. It was a ban on a particular method of abortion used in the second trimester. After about 15 weeks or so of pregnancy. And so those two laws are currently not enjoined, and those injunctions were dissolved. If the court were to enjoin SB 23, at that moment, the D&E ban would remain in effect. Now, there are also injunctions that were issued by the Hamilton County Court of Common Pleas. So those are pending in state court. Those cases are being decided, and those injunctions were decided under the Ohio Constitution, where the Judge Hathaway already found that the Ohio Constitution protects a right to abortion and requires strict scrutiny. So those cases are currently not affected by the Dobbs ruling because they were under the Ohio Constitution. Other than that, I think there might be one other, there's one other case that's ongoing in federal court because it is not under the claims, although it involves abortion restrictions, the claims don't involve Roe and Casey. And then there's one, I think, motion by the state to reopen an old case from several years ago. But those are not abortion bans that would significantly change the status of the law in Ohio.
All right. So if the court was to grant the relief you're requesting and make it very specific, the only thing being enjoined was the application of this new statute. It was actually a 2019 statute that you're challenging. Let me make sure I get it right.
Yes.
SB 23, 2019. I have a complete copy of it here that we went through. If the court was to make it very specific that the enforcement of that statute is the only thing being enjoined, then that would not create challenges for providers or law enforcement officials in Ohio to understand exactly where things stand, at least in your view, right?
That's correct.
Right, go ahead. I think that's something the defendants will address in their arguments, because I want to make sure that if there is a disagreement on that, the court understands, because the last thing the court wants to do is to make a challenging situation worse with an order that is not fully informed. Okay, I think I understand the plaintiff's position on that. The only other thing before we move on to the defendants, and I will give the plaintiffs a chance for rebuttal because it is their burden. The only other thing I'd like to hear the plaintiff expand on, if they want to, is how the plaintiff thinks the court should consider this healthcare freedom amendment. Because it seems that in the briefing and in your argument, you sort of just suggest that it's something that the court should consider when it's reading the due process protections and the equal protection arguments as an expression of policy by the voters of Ohio to recognize some sort of freedom of choice in healthcare and privacy. But it's sort of unclear to the court exactly how you think that amendment applies in this context. It's not very clear. Particularly, the court's question is about subsection C of Ohio Constitution section 51, which would seem to have some application to the statute at issue, just read on the plain text of the statute. Subsection C, and just for the record, this is an amendment that was passed, I believe, in 2011 on a referendum petition. It was apparently advocated by folks who opposed the ACA, the federal ACA, but the language of it, just looking at its text, states, no federal, state, or local law or rule shall impose a penalty or fine for the sale or purchase of health care or health insurance. And I don't think there's any dispute that abortion procedure is a medical procedure and it is health care. So I'm just wondering if you can expand on that. How are we supposed to apply that in the plaintiff's view? Because I'm not getting a clear picture from the briefs. If you could help us.
Absolutely, Your Honor. And I'm sorry, the sound is a little wobbly. I did hear everything, but I'm going to just adjust my internet for a moment. If it just.
Okay, go ahead.
Okay, Your Honor, can you hear me?
Yes, we can hear you.
Great, thank you. Yes, I'd be happy to answer that question. So that's right. So we cite and rely on the Ohio Healthcare Freedom Amendment to say that, so we are not asserting that abortion restrictions must be struck down under that amendment alone. So we do not read that amendment alone as necessarily conferring a right to abortion. Your Honor, largely because it's not clear that provision is necessarily self-executing, but we do believe that the language of the Healthcare Freedom Amendment is sufficiently broad, and it really does express a very broad value of healthcare freedom that, as you noted, Ohio voters embraced by a 2-to-1 margin. And there was, whatever the intent of the drafters of that provision, I mean, that's not relevant to, the only thing the court can look at is the text. The only thing the voters voted on was this broad protective textual language. So we rely on the Healthcare Freedom Amendment because of the way that the Ohio Constitution should be read holistically, and to view all of the provisions sort of harmoniously. We view the Healthcare Freedom Amendment as supporting our view that that the right to substantive due process right protected by Article 16 includes the right to abortion. So, I mean, which is not to say that it would be unreasonable to find a right to abortion in that amendment. I mean, there's a recent case out of Wyoming. Wyoming's constitution has a somewhat similar provision, and the court did rely on precisely that provision in striking down that law. But we don't think the court needs to find that, because we think that the three provisions read together lead to the sort of irresistible conclusion that abortion is protected as an aspect of the due course of law, the inalienable rights, and the Healthcare Freedom Amendment.
Do you one other question before we move to the defendants, because the plaintiff cites this case that the court took an interest in. This is the 10th District's Court of Appeals opinion from 1993 in Preterm-Cleveland versus Voinovich. The defendant in its response argues that this hurts the plaintiff more than it helps them, but the court has taken the time to review the decision carefully. And it is a clear holding by an appellate court in Ohio in 1993 that the Ohio Constitution, that the provisions that you're relying on are broader and recognize so-called, quote, natural law, which is not expressly recognized in the federal Constitution, and that under the Ohio Constitution, there is a right to an abortion, independent of the federal constitutional right. Now, at that time, Roe was in effect, and the opinion goes on and on about Casey's effect, but there's a footnote 9 in there that recognizes and anticipates the situation we're in today, where Roe is no longer the law of the land. And it says that an Ohio court would be free to find a statute to violate the Ohio Constitution, even though it does not violate the United States Constitution. That's the situation you're arguing today, right?
That's exactly right, Your Honor.
Right.
We're saying it's an independent right under the Ohio Constitution. Of course, we recognize that the 10th District decision is not binding on this court, but it's certainly persuasive precedent, along with decisions out of the Ohio Common Pleas Court. And then, of course, there's the Ohio Supreme Court decision in Steele, which again recognizes a substantive component of the due course of law clause, saying that the rights to reproductive decision-making, sexual autonomy, and so on are protected by the due course of law clause. Of course, that was even before. Both preterm and Steele were before the Ohio Healthcare Freedom Amendment, which again,
Right.
we can just further support.
And that's sort of where I was going with this and wanted to get some comment, actually, is that a 1993 Court of Appeals decision that, although it's not binding as far as this court can tell, is still good law in Ohio, has not been reversed, has doesn't even have a yellow flag on it on the court's service. In fact, it has positive citations. So a 1993 decision recognizing an Ohio constitutional right to an abortion was in place when the Healthcare Freedom Act or amendment was passed. The drafters of that amendment did include several specific carve-outs that it did not do, but they did not address the issue of abortion, even though it was, I won't say established at that time, but it had been held. And so far as I can tell, there is no Ohio Court of Appeals decision or a Supreme Court decision holding to the contrary. I assume someone would have brought it to our attention. Is that right?
That's right, Your Honor. We are not aware of any to the contrary. Of course, he hasn't been presented to the Ohio Supreme Court. So that would explain why there isn't one recognizing the right either.
Okay, all right. I just want to make sure the court was fully aware of the circumstances before we move on to the defendants. And this enables the defendants to have a sense of some of the things that are on the court's mind and to address them in their arguments. So we're going to do that now, unless anyone else for the plaintiffs feels the need to chime in on the plaintiff's case in chief. I'm not seeing anything. So let's move to the defendants. If you can use the podium, I think that will help the folks on Zoom hear you. Okay.
So as an initial matter, Your Honor, state that like to bring the court's attention that the Supreme Court has not granted plaintiff's application for dismissal of an Yost action involving the same parties and the same claims made there. That court then still maintains jurisdiction over the issue now for this court.
So, so are you saying that the court can't consider this matter?
Under the Ohio law, which is adopted rule for jurisdictional priority, yes, this court should not consider this scenario today.
Well, obviously, the Supreme Court takes priority over our little trial court here. Okay.
Yes. And
Folks on Zoom, can you hear Ms. Narok? No, they're shaking their heads.
It's a bit garbled.
And
Sorry.
I think it's important that everybody hear each other so that they can respond. Mr. Fitzpatrick, can you turn the or move the microphone maybe into the middle here so the folks on Zoom can hear? So is the port long enough? You need to turn the screen, that's fine too. Maybe turn. Yeah.
Judge, this might help. I might have a hard time with you, but I can always move that.
Go ahead. Please start speaking clearly. I think you'll hear.
would you like me to restart?
Yeah.
Okay. I wanted to bring to the court's attention that the Supreme Court has not granted plaintiff's application for dismissal of their mandamus action involving the same parties and the same claims as are made here. That court then maintains its jurisdiction over the issues now advanced in this motion. Under Ohio law, which has adopted the jurisdictional priority rule, this court lacks jurisdiction to issue a TRO today.
Can everyone on Zoom hear Ms. Sarah? Yes, okay, they can hear you. Please try to use your outdoor voice so that we can get as much involved.
Okay. There is no need for emergency relief here because the emergency plaintiff's claim is one of their own making. The plaintiff's strategic choices defeat their claim for TRO. TROs exist to preserve the status quo long enough for the aggrieved party to seek a preliminary injunction. At this point, the Heartbeat Act is the status quo in Ohio. It has been effective law for 2 months now, over 2 months. And since July 1st, plaintiffs knew that they could not obtain emergency relief in the Supreme Court, but they decided nonetheless to wait another 2 months before seeking emergency relief here. Now, in deciding a temporary restraining order, the court must consider whether the movement has a strong likelihood of success on the merits, whether the movement will be irreparably harmed if the order is not granted, what injury to others will be caused in granting the motion, and what the public interest, if it is served or harmed by granting the motion. Of course, states always suffer irreparable harm when their constitutional and permissive laws are enjoined, and giving effect to the will of the people by enforcing laws that they and their representatives have enacted serves the public interest. Now, plaintiffs cannot satisfy the first 2 prongs of this test, so they are not entitled to a TRO. Plaintiffs here ask this court to recognize a new right, a right to abortion under the state constitution, and enjoin duly elected legislation that has been effective law for over 2 months, the Heartbeat Act. On that basis, the Ohio Supreme Court has never held that there's a right to abortion in the Ohio Constitution, and no provision of the Ohio Constitution can be reasonably interpreted to contain a right to abortion. Now, abortion was illegal by statute in Ohio starting in 1834, and at all times during the drafting and adoption of our current constitution, and remained a crime until the decision in Roe v. Wade. And throughout the 50 intervening years, the Ohio General Assembly has enacted legislation imposing greater and greater restrictions on abortion's practice. Now, as to the plaintiff's argument that there is a substantive due process right found in the Constitution, regardless of the 10th district case, which I can opine on further in my argument, we have adopted a test here that is similar to the federal court test, which is enunciated in Washington v. Luxburg, which requires that the right being recognized be deeply rooted in the nation or state's history and tradition. Now, being that abortion was a crime for over 100 years in Ohio, cuts sharply against that holding as well.
What about the last 50 years?
The last 50 years, we were under a different regime. Roe v. Wade was required states to allow abortion in their boundaries, regardless of what their laws were. So Ohio had a statute in 1973 that criminalized abortion practice that was abrogated by the Supreme Court's decision in Roe v. Wade. As I said just a moment ago, the General Assembly has worked diligently to restrict the abortion practice in the state of Ohio on behalf of Ohio citizens. So for as long as the federal court imposed abortion in Ohio, Ohio has worked very diligently to try to cabin its performance and its pervasiveness. The only rights asserted here in this litigation, however, are the rights of pregnant women and potential patients of the plaintiffs, the abortion clinics. To litigate on behalf of third parties, the litigant must show that they have suffered their own injury in fact, that possess a sufficiently close relationship with the person that possesses the right, and show some hindrance that stands in the way of the third party seeking claim. Now, plaintiffs assert this in a footnote that it is well established that they have third party standing to bring claims of their patients here today, but they make no attempt to show the necessary elements under Ohio law. Neither the Ohio Supreme Court or the First District Court of Appeals has held that abortion clinics have a third party standing to assert claims on behalf of their patients in the 50 years of Roe inspired litigation or before. But case law shows that a third party has no fundamental liberty interest in terminating another's pregnancy. Now, plaintiffs dealt with this issue in their argument, but State v. Moore was a second district case, which the First District Court agreed with in its holding in State v. Alvinieri, in which they stated certainly the state's interest in protecting pregnant women and unborn children outweighs the third party's right to terminate another's pregnancy by specifically defining conduct that is deemed to be criminal. Because the law in this district holds that the state's interest is superior to the plaintiff's right to terminate another's pregnancy by conduct deemed criminal, which is exactly what the Heartbeat Act does, then plaintiffs cannot suffer injury in fact by being denied the ability to perform abortions by the law. They also cannot be injured by having to close a clinic, which is also a direct consequence of the state's superior interest in prohibiting a third party from performing abortions after fetal hormones are detected. And the injury is also claimed by only one plaintiff in this case, and all plaintiffs must show that they have suffered an injury in fact in order to secure a TRO. As to the additional harms that are listed in plaintiff's briefing, for instance, canceling appointments and turning patients away, plaintiffs do not say that these harms represent their own injury in fact, or provide any evidence of actual harm. In fact, the affidavits contain anecdotal accounts of what patients may or may not have said. However, we have not had the opportunity to cross-examine or speech with any of these patients, so we only know that what it is their account of this hearsay in its purest form.
Well, we just said. It's a little bit of a fraud area, but let's talk about that for just a second. Because the plaintiffs in the filing thought about the issue that's been a matter of great public concern, the 10-year-old rape victim who had found at the beginning, who I believe your boss got in hot seat a little bit about. They didn't doubt the truth of the story, and that's actually what we're seeing now. It's key. It's test these stories, know if they're true or not. I believe it's been pretty well established in public opinion that story was substantially true. And then the 10-year-old, because of this law, had to travel to Indiana to get an abortion because she was through the 6 days past the date and a lot of details of it.
I actually am not familiar with the exact timing of her abortion.
It's in brief, you guys do that. I mean, here's the thing, after all the investigation has been done, now that the results didn't happen.
No, that is not what our statement.
This 10-year-old is denied care here in Ohio because of this law.
It can only be irreparable harm if she has a constitutional right to an abortion in the state of Ohio. And the state position is there is no right to the Ohio Constitution that gives her a right to abortion. So she cannot be irreparably harmed by being denied access to an abortion in the state of Ohio.
Well, all right, I understand this is trying to make a very long argument that there's no right that ends the discussion. But the statute would be then also has these exceptions to it. And I don't think anyone's well known those exceptions and the problems that those exceptions create. The plaintiff makes a pretty substantial argument that those exceptions are phrased in a way that practically means abortion will be denied, even when it might be needed. Check for life, health of the mother, in this case, a 10-year-old rape. Now, as a practical matter goes, I think that if you want to talk about the absence of irreparable harm, you should direct your comments to those exceptions and whether or not the argument plaintiffs think that they are unworkable. And as a practical one, would mean that no provider is going to be down the road because they're wrong, they're challenged, they're exposed to criminal penalties. And if you read the statute, as we pointed to, if a provider is willing to provide an abortion under those circumstances, but he or she is making a decision that there is a harmful language correct, a serious risk of substantial and irreversible impairment of the mutual body, they don't make that call. They have to be prepared to defend it. They have to document that time forcefully do that with that medical records. So I would love to hear you address how an exception actually works and why you think that rather than say there's no way to report it, say why that is. Because I think that goes to the stuff that's, explaining that this is, in fact, there are at least a complete as a practical.
Excuse me, Your Honor. I'm so sorry to interrupt. I apologize profusely, but the folks on Zoom can't hear when you speak very clearly.
Well, absolutely. Well, this is good that we have time to out your response. So for the folks on Zoom, we have one large boom mic in the courtroom, and my staff had moved it over to Ms. Nayrog so that you could hear her. I stopped her in her argument about irreparable harm to ask her to direct some comments to the effect of the exceptions in the statute and the plaintiff's argument that those exceptions are ineffective and effectively mean that this is a complete and total ban. And what drew the court's attention was a reference to the evidence that the plaintiffs had presented in their affidavits as being anecdotal and not subject to cross-examination or testing. And so that drew the court's attention. one of the cameras in the room is going off and making a noise. It's one reason we like to limit it to one camera. There we go. Why that drew the court's attention, and I want Ms. Nayrock to respond to it, is because we all know, and it's in the plaintiff's papers about the highly publicized case of the 10-year-old rape victim, which Ms. Nayrock's ultimate boss made extensive public comments on. And I think it's relevant here. If they're going to, if the defense is actually going to argue there's no evidence of irreparable harm, we have that public case, which the state of Ohio's Attorney General has publicly commented on. And I don't know if he ever apologized, but I think he sure should have. Then I think we ought to get straight to it and talk about what's the effect of that statute. And that's what I've asked Ms. Nayrock to respond to. Could you move the microphone back so the folks on Zoom?
Yep.
Here?
So the act contains two exceptions that allow for a physician in his medical reasonable judgment to perform abortions after cardiac activity is found. The first applies to abortion when it is necessary to prevent the patient's death. And some examples are given in the actual statutory language. The second applies to when there is a serious risk of substantial and irreversible impairment of a major bodily function. And that is defined in the act as, meaning a medically diagnosed condition that complicates the pregnancy of a woman as to directly or indirectly cause substantial or irreversible impairment of a major bodily function. And that is mainly limiting the application of these exceptions to physical conditions and not mental conditions. And that's made clear in statutory language as well. These limitations and exceptions are nearly identical to the prior exceptions that were allowed for abortions past the previous limitation, which was viability post in pro. We did not hear as many objections to these exceptions at that time. And again, yes, the physician does need to attest to the fact that he has determined that there is a risk to the mother's life or that she may have some kind of serious impairment. But that is not unworkable. It's actually a very clear statutory guideline for these doctors, and it is provided that it needs to be in their reasonable medical judgment. So we are going to defer the physicians in making judgment calls on these situations as long as they're doing so, in their reasonable medical judgment. I don't believe that anyone at this point denies that there was this case of a 10-year-old girl. And I don't believe that the Attorney General actually said that he did not believe. He said we could not find any evidence. We had, our office had been trying to find evidence that this had occurred and were not able to substantiate it. He in no way was trying to impugn the veracity of the statements made by a 10-year-old girl.
Well, then it turned out it wasn't.
Yes, when we and eventually we did learn of that case. But again, it may be a harm. It certainly is a good situation, and no one says that it is. But as a legal matter, it is not irreparable harm. There is no constitutional right for her to obtain an abortion. But there is certainly an aspect of these exceptions that she very likely would have fallen within. Certainly, a 10-year-old could sustain serious bodily harm, and no one has argued that she could not have fallen within these exceptions.
But yeah, she couldn't get that care at the time.
It's not that she couldn't; it's that whatever provider she went to, and I don't know all the details, did not offer her an abortion care. They rather sent her to Indiana instead.
I think we can all understand why, right?
But I don't.
Well, because that position will have to be standing behind their opinion that it fits within one of the exceptions, or they fell under the 5th degree.
Well, as long as it's made in his reasonable medical, judgment, I don't think he has to worry that he's going to be prosecuted, for performing an abortion in this instance. But
there we have. If the physician is willing to take that risk and be confident in that they won't be prosecuted, then the exception works. Right? But if the physician is concerned and practicing defensive medicine or being cautious, then people are going to be denied care that they might actually be entitled to under the exception because of the risk of criminal prosecution. Do you agree?
I would agree that that potentially could be an outcome, but it is not in and of itself a direct consequence of the statutory language. The statutory language, I feel, was very clear. We feel it's very clear in how the exceptions are to function, and they are almost exactly the same exceptions that are, that were applied in the former portion of litigation legislation that hasn't violated.
Well, I think we should just be very honest about what it is we're actually talking about. And I think that a lot of the arguments dance around it. This statute says that a doctor who provides a procedure to a person, if they're second guessed later on about whether or not it actually presented a serious risk of substantial and irreversible impairment of a major bodily function, if they're second guessed after the fact, they are at risk of being prosecuted for practicing medicine and they're faced with a felony. If there is any right to an abortion under the Ohio Constitution, as good law from the 10th District Court of Appeals says there is, and has never been reversed, then how is that situation not a substantial burden or a substantial impairment of that right? That's what I'd really like to hear the state articulate. Criminalizing or putting a physician at risk of criminal prosecution for a felony and then for licensure. To make that judgment call, don't we all expect the physician to do what they did in the case of the 10-year-old girl and say, go somewhere else? I don't want to take that risk. If there is some right to an abortion, regardless of whatever the parameters are under the Ohio Constitution, which I know you don't agree with, but if there is, assuming for the sake of argument, how is that not a substantial burden on that right?
A substantial burden on the right to obtain an abortion if one exists. The Constitution, is that your question?
Yeah.
I would say that the exceptions are clear in the statutory language. I understand that a physician might be fearful of prosecution, but again, the provision of the language of in your reasonable medical judgment, as long as he is exercising reasonable medical judgment, then he does not have to fear prosecution for performing an abortion that he feels could prevent death or serious bodily injury. I don't think that actually swallows the rule. I think that it actually does provide a very clear guideline for when abortions can be practiced after heart tones or cardiac activity is found in a pregnancy.
And does the state have any evidence on that point that there are physicians in Ohio who have no problem with exercising that judgment and putting them at risk of criminal prosecution? I mean, do you have affidavits from physicians who say, I'm okay with this language, I'm going to continue to exercise my judgment and provide this procedure when it's necessary? For example, in the case of a 10-year-old rape victim or someone else?
I don't have affidavits, but that is not to say that there are not doctors that are willing to perform abortions in the event of, in fact, the director of health obviously feels that these exceptions are adequate, the language is clear, and I feel as though the statutory language also provides a very clear guideline and provides examples of what would actually be substantial bodily harm, and what would actually be a condition that would put the woman's health at risk of potential death.
Go.
No, that's okay. And all of this is to say that obviously in our analysis on the legal issue, irreparable harm has to be tied to a constitutional right or some rights under law. And it is our position, and we believe we have demonstrated there is no right to abortion in the Ohio Constitution. They also are not able to meet the third element of the third party standing analysis, and that is really fatal for plaintiffs' ability to bring these claims on behalf of the patients. Plaintiffs provide these anecdotal accounts of these patients that are obviously distraught because they're unable to obtain an abortion because there's already cardiac activity detectable, some as early as 5.5 weeks, according to plaintiffs' affidavits. Yet none of those patients have chosen to file a suit in the 2+ months since the Heartbeat Act has been effective law. The litany of injuries claimed have been felt almost entirely by these purported patients. Not a single patient has chosen to file a suit of their own. And any claim of the short time frame provided by the Heartbeat Act actually undercuts any possible hindrance to their patients advocating their own rights. If the act prohibits abortion at the point so early that when many women do not know they're pregnant, certainly that is adequate time for her to bring a suit and have a hearing on the TRO, as we are doing here today and as plaintiffs have done in this last week. And considering that plaintiffs freely admit that they historically performed abortions in the 16th, 19th, and 21st week of gestation, that is certainly adequate time for a patient to advocate for her own rights in a court of law and obtain a TRO in service of trying to afford herself abortion care. And Roe itself was not a case that was brought by the abortion provider, but by an individual pregnant woman, a woman. And the plaintiffs only cite 2 appellate court decisions on this point at 2 third-party standing, and both of those cases deny third-party standing to those plaintiffs. And this court should similarly hold that plaintiffs lack standing to sue here. They must show that they have actually sustained the harm in fact of their own, and they have failed to do that. Plaintiffs' lack of diligence in filing the complaints and the motion for temporary restraining order is inconsistent with their assertion that they will suffer immediate and irreparable harm. The plaintiffs have not made any showing that they have any right violated by the Heartbeat Act or any irreparable harm of their own, nor can they leverage the harms of their patients or potential patients to fill that void. They must show their own harm injury in fact, and they have failed to do so. The plaintiffs have failed to meet their burden to show that they have third-party standing on their own or their own injury in fact, and they are not entitled to a TRO in this court, and this court should deny that TRO specifically because the mandamus action is still ongoing, and thus this court lacks jurisdiction to enter a TRO in this case.
All right. I didn't want you I don't think you addressed the healthcare freedom in your arguments. I know you did in your file.
Right.
And I understood your file and I actually thought it was somewhat effective to give examples of other things that might be called healthcare, that if the argument of the plaintiffs was taken to its logical conclusion under this healthcare freedom amendment would also be illegal. That was somewhat effective. I guess my question is, because the court looked, as far as the court can tell, there has been no one has ever tried to argue that the healthcare freedom amendment had application to limit any regulation of healthcare. So, I mean, we just don't know because it hasn't happened, or argue. I pulled the section here, and it looks like there has been one case ever that discussed the healthcare amendment or the healthcare freedom amendment. And it found that it fell within an exception that was in the text of the amendment itself. So, I mean, are you just saying just because it hasn't happened before that someone has asserted this amendment to have some effect on a regulation of healthcare that therefore it can't be applied that way? Is that the argument of the state?
Well, the argument of the state is that neither the people of Ohio nor the drafters ever anticipated this would incorporate any kind of right to an abortion in the Ohio Constitution. This was a reaction to the Affordable Care Act and mainly dealt with the purchase of insurance on state exchanges versus being able to purchase insurance from any provider that Ohioans would want to purchase from. You mentioned subsection C, and that really does forbid government from punishing the sale or purchase of healthcare. But again, it's referring in the majority to insurance. Of course, the state can outlaw or ban certain practices, medical practices, and as you noted, we list several that are obviously banned for good reason and are considered perfectly constitutional under even the healthcare freedom amendment. So I don't think you can reach as far as plaintiffs to say that it does.
The text of the amendment, this is a constitutional amendment in the Ohio Constitution. It doesn't say health insurance, it says health care or health insurance, right? I don't know why they use that language. If they were only trying to deal with health insurance, they didn't say that. We have to follow the text. And so if there is an Ohio constitutional right to be free from penalty or fine for the sale of health care, which is exactly what that statute says, how does that not have application in this context? Because that is exactly what Senate Bill 23 does, is it provides a penalty for the provision of healthcare. Why shouldn't the court consider that at all in this context? On what basis, I guess, what authority do you have? A court can simply say, well, I know, because I know that that's about health insurance, and I can just ignore the actual text of the Constitution. Because reading your brief as a whole, as the plaintiffs would say holistically, there's a lot of textual argument in here. And I'm just wondering if the state is a textualist when it likes the text, and some sort of interpretivist when it doesn't, because we've seen where that goes in other cases. It seems convenient. How can I ignore the text of the Ohio Constitution that the voters overwhelmingly adopted? Because the language has application. There's just no, I mean, there's not any way to say it doesn't. Say it wasn't intended that way, or you can find some authority to say we shouldn't consider it. But I haven't heard any of that. You have anything for us?
Well, look at subsection B. That language expressly preserves the legislature's power to punish wrongdoing in the healthcare industry, which presupposes a power to determine what qualifies as wrongdoing. Obviously, the General Assembly's power to prohibit or regulate circumstances in which procedures can be offered is actually upheld in section D. It's actually makes clear that that is still the ability of the General Assembly to regulate healthcare and what kind of procedures can be offered. Obviously, the amendments, since even after the amendment's passage, Ohio continues prohibiting the unlicensed practice of medicine. It prohibits the use of anabolic steroids. It prohibits the use of female gender mutilation. All of those can be considered healthcare in certain instances, and they are not. They don't come with this language because section D preserves the right of the legislature to regulate the provision of healthcare.
I appreciate you making the argument. It doesn't say regulate the provision of healthcare. It says deter fraud or punish wrongdoing in the healthcare industry. I think we would probably agree it's not the most well-drafted piece of constitutional language. Would that be fair?
I would say that if you're trying to apply it in this context, it certainly would appear that it's not well drafted. But I think as it applies to the situation and circumstances under which it's actually passed, I think that it is as well drafted as one of this.
Very good, Ms. Narek. I appreciate your arguments very much. there's anything else you want to put on the record, or your co-counsel wants to put on the record, or anyone else for the defendants wants to put on the record, you're welcome to do so. Okay. All right, if we can have rebuttal for the plaintiffs, or if there's anyone else that wants to put anything on the record.
Okay, yes, thank you, Your Honor. I would like to make a few points in response. First, I want to just, so some of these points are addressed in our reply brief, although I realize it was filed very shortly before this hearing. So I will just refer the court to that brief for some of these points as well. But I want to explain, first of all, in terms of the Ohio Supreme Court case, the plaintiffs did file an application to dismiss that case on September 2nd, which was this past Friday. My understanding is that because the case has not proceeded or even been granted, it is just a ministerial matter that dismissal will be granted. Our understanding is that this court has jurisdiction, that this court, this is a separate case. We are asking for different relief in this case. I'm not sure what provision the defendants are relying on to say that this court doesn't, because they didn't cite anything in their brief to that effect, I don't believe. But our understanding is that this court does.
Let's talk about that for just a second, Ms. Hill. What happens if I issue the relief you're requesting, and then tomorrow the Ohio Supreme Court denies your motion for voluntary dismissal by some chance? I guess by you saying it's a ministerial act, are you saying, well, that's just not going to happen? They're not going to.
Sorry. Yeah, our understanding is that plaintiffs have a right to dismiss the case that they instituted in the Ohio Supreme Court, and that where the Ohio Supreme Court has not yet taken any steps to hear the case or indicated even whether it's granting the petition. So that is my understanding. I think. Yes, that's our understanding.
Okay.
That it's merely a clerical matter. But I also do want to take a few moments, because the defendants addressed this point, to also talk about sort of why we're here and the sequencing of events. We did initially file, and within days after the SB 23 went into effect, we filed immediately in the Ohio Supreme Court and sought emergency relief, which was denied. And we were at the time hoping to get both an expedited schedule and expeditious ruling out of the Ohio Supreme Court that would be final and binding and provide sort of definitive guidance that only the Ohio Supreme Court can really provide for abortion providers and patients in the state of Ohio. That obviously hasn't happened. So we were sort of balancing the need for that kind of ruling against the increasing harms suffered by patients and by our clients, till eventually it got to the point of sort of the tipping point where we just couldn't wait any longer. And as I noted, the one clinic is on the verge of closure. Kentucky has now eliminated abortion rights, and Indiana is about to. So that's why why we are here today asking this court to issue a temporary restraining order. I also want to address the sort of related point of the status quo and what is the status quo here. For purposes of a TRO, Ohio law states that the status quo is, and I'm quoting, quote, the last actual peaceable uncontested status which preceded the pending controversy. And again, cases to that effect cited in our reply brief. So here, the status quo is clearly 50 years of abortion access in Ohio. It is the SB 23 is not the status quo, even though it has been in effect for a couple of months. There are plenty of cases in which a law has been in effect for a couple of months, but the court finds that the status quo was the pre-law state of affairs. So SB 23 obviously has been contested since it was passed. It's been the subject of a lawsuit virtually continuously. So it remains contested. And obviously the status quo is the state of the law that we discussed earlier before SB 23. I guess I want to make a couple more points. One, I want to address third-party standing. There again, we cite in in a footnote in our opening, and we discuss again in our reply brief, numerous cases in which the Ohio Supreme Court and lower courts have stated that third-party standing is acknowledged, is accepted in the Ohio courts. The reason for that is that, again, it is very clear, the Ohio Supreme Court has made it very clear that Ohio follows federal law on standing, as including third-party standing. And it remains the case that abortion providers have third-party standing to assert claims on behalf of their plaintiffs. That's true under federal law. Dobbs is no exception to that. Dobbs didn't change that. Dobbs was an example of that. Dobbs was an example of an abortion clinic asserting and the Supreme Court accepting third-party standing in that scenario. We also have numerous Court of Appeals cases, or at least a few, in which abortion providers have asserted third-party standing on behalf of their patients in Ohio in state court. And like I said, numerous Ohio Supreme Court cases that don't necessarily involve abortion providers, but that make it very clear. So it's, you know, it's far too late in the day to question this. The reason plaintiffs are not required to go into the details of meeting the requirements of third-party standing, because it's been so clear that the requirements are met and have already been recognized. Finally, I want to say a few words about, well, I guess two more points. One, I want to say a few words about the exceptions to the law, and in particular, the medical exceptions to the law. It's entirely unclear to me. I know there was a long discussion about the 10-year-old rape victim. And again, this is not an isolated incident. There were minor rape victims discussed in our affidavits. I mean, the Attorney General himself surely has access to the crime statistics that show multiple cases of rape against minors, against children in this state every year. I just cannot understand what aspect of the exception for a serious risk of substantial and irreversible harm to a major bodily function, impairment of a major bodily function, apologies, that this would fall under. I don't understand. I can't see how that scenario fits under the exception as the defendants are trying to contend. Finally, I guess I just want to say a few words about the Healthcare Freedom Amendment. Again, we've made it clear that we're not contending that the Healthcare Freedom Amendment is independently, all on its own in isolation, what requires this court to find that SB 23 is unconstitutional. We also, even if it were, we would not be saying that it's an absolute bar to absolutely any regulation of healthcare. I mean, it has very broad language, that's clear, and it appears to function that way. But like any constitutional provision, it would be subject to interpretation by the court. A court would presumably, you know, apply some form of scrutiny to determine whether or not a law would be struck down under that amendment. But you know, we contend instead that this language, again, is a very broad affirmation that Ohioans possess a right to healthcare freedom, and that they voted overwhelmingly for this very broad language. In fact, 2-1, which is, I think, the amicus brief that's being filed today will also indicate that a majority of Ohioans do support abortion rights. So it's not at all inconceivable that they could have been thinking that they were, as a matter of fact, it's quite likely that they were thinking that this included a right to abortion, which is, after all, healthcare. So I think, unless Your Honor has any questions about any of that, I think that's all I wanted to respond to.
Thank you, Ms. Hill. Anyone else want to put any statements or arguments on the record for the court's consideration of this matter? All right, no one else, anyone from the defense? Anything else you want to add for the record? Go ahead. Go ahead. We want to have a full argument. Move the microphone around so the defendant.
I would like to first address the plaintiff's last argument there about how the healthcare freedom amendment doesn't actually provide a right, but it's in pari materia with all the other rights that they've identified, which sounds suspiciously like the holding in Roe v. Wade in the first instance. We're not exactly sure where it is, but if you look at it all together, here's this right. Well, we know for certain that nowhere in the Constitution is it actually provided in the text that there is a right to abortion. We know that the House Court has never held that there is a right to abortion under the Ohio Constitution. And our long history and tradition in this state that abortion has been a crime until the federal courts forced Ohio to allow abortion within its borders. Now, as far as the 10th district case, which you were asking about earlier, the text of that case, they actually find that there is no reason under the circumstances of that case to find that the Ohio Constitution confers upon a pregnant woman a greater right to choose whether to have an abortion with their child that is confirmed by the United States Constitution, as explained in the plurality opinion in Planned Parenthood. Stated conversely, we see no reason of finding that the Ohio Constitution places greater restrictions upon state action than are placed by the United States Constitution as construed in the plurality of PKC. So in that way, this is not a broader right, and even the 10th district recognized that. They did not interpret Ohio's Constitution to do more than the United States Constitution did. And certainly they were guided by the Roe v. Wade decision and the decision in Planned Parenthood v. Casey. And in the time since 1993, no other court has made that holding, with the exception of the Common Pleas Court here in Hamilton County. And certainly the Supreme Court has never upheld or affirmed that decision either. So it is, while it may be persuasive, it is not actually a holding that is binding on this court. And we argue that looking at the textual provisions of the court, and again, our deeply rooted history and traditions, there is no right to abortion in the Ohio Constitution.
The court understands your arguments. I'm curious. It's about cherry picking comments from a case. I don't know what part of the 10th district's opinion you were reading from. The court studied the opinion to try to, and it does contain a good history of the state of abortion litigation at that time in '93. But it was clear, at least so far as this court reads the decision, that the court found, quote, "It would seem almost axiomatic that the right of a woman to choose whether to bear a child is a liberty within the constitutional protection," end quote. That's the 10th district in 1993 applying the Ohio Constitution. So it certainly is something that the court has, I believe, even an obligation to consider, even if it's not that. So the court will consider it for what it's worth. All right. Anything any of the plaintiffs want to say in response to the state's final argument? Because the plaintiff does have the burden, and the plaintiff does get the last say.
We agree with the reading of Preterm v. Voinovich that it recognizes a right under the Ohio Constitution and finds, in fact, that it says that it was applying the undue burden standard to the court's interpretation of the Ohio constitutional provisions, except to the extent, if any, that they afford greater restrictions upon state action than are imposed by the federal Constitution. So recognizing the possibility also that the Constitution is even broader than that.
All right.
Thank you.
Very good. The court understands the arguments. Just a couple of closing comments, and to see if anyone does want to advance in the argument on it. One of the issues that the court is not exactly clear on what to make of is the fact that several Ohio County prosecutors are not opposing the issuance of the TRO in this case. I believe, and I'm sensitive to the fact that not opposing it doesn't necessarily mean they support it. They're simply not opposing it, but at least one, I believe, has filed with the court and indicated that they actually support the issuance of the TRO. Does either party want to address what the court should make of that? Because I don't think the relief being requested is that the court limit the scope of a TRO in any way. And but I'm not clear on what effect that should have in anyone's view on the court's consideration of this matter. Or if any of those prosecutors' offices who are on the line want to enlighten the court about why they're not opposing it, that might be helpful to the court, because we're not very clear on what to make of that and how to take that into account in coming up with a decision in this case. Does anyone want to try to help? I'm seeing no volunteers whatsoever. Okay.
Well, Your Honor, I would just emphasize that the plaintiffs do require broader relief than just enjoining the county prosecutors, even if they are willing to be bound, because the law carries numerous penalties, including penalties that can be enforced by the state medical board and by the Department of Health. And so it would not be sufficient only to enjoin the county prosecutors.
Okay. All right, good. I guess, and I see Ms. Sears is unmuted.
Yes, sir. I've been involved in several of the Planned Parenthood pieces of litigation, and what has been rather problematic is, at least in my view, we are nominal parties, and that my understanding from one of the first cases I was in is that we are here in terms of an injunction, if it were issued, would obviously be enforceable in the counties in which Planned Parenthood has agency. Additionally, it's always been my position, of course, that should a court find the law unconstitutional, then as a matter of duty, the prosecutors would be they would be bound to follow the rule of the court. Obviously, as prosecutors, we don't enforce unconstitutional laws. The other position that I have taken throughout the years is that we represent county agencies and county elected officials, and we do not have a role, in my opinion, necessarily in representing the General Assembly. So at least from my perspective as a nominal party, my goal is to get out of the way, if you will, of the court's determination on behalf of the parties that are representing in the Attorney General's state interests. So at least with regard to, and in the past, we've actually taken the position as a group that as nominal parties, we essentially would get out of the way of the court in terms of determining the constitutionality of a statute and abide by whatever ruling the court would make. I'm not sure if that helps elucidate everyone else's position, but that's essentially been our position for quite some time.
All right. I see some nods from some of the other county prosecutors. That's very helpful to the court, not having handled a case like this before. So thank you, Ms. Sears. That's very helpful. All right. If anyone else has anything to add for the record before we adjourn, please let me know now. Okay. Very good. The court is going to take this matter under advisement and not issue an opinion at this time. The court would like to investigate the threshold issue of jurisdiction and the effect of the Supreme Court still not having dismissed the case. So the court does not have the benefit of any briefing on that unless it's addressed in this reply brief. It was not addressed in the state's response, not faulting the state for that. These were very hurried proceedings, and the responses, filings and the responses were excellent and helpful. And were read by the court. So the court will take that issue up very quickly and try to determine if it does indeed present a problem for the court considering this case, and get an entry on as quickly as the court is able. So thank you all for your arguments and your excellent work in this case. We'll get an entry on as soon as possible. Thank you very much.
Thank you, Your Honor.